Good morning, rather good afternoon, everybody. I am Dr. Charu Mathur. I am an AOR with the Supreme Court and editor with EBC Learning. I welcome you all for our webinar on revisiting PIL jurisprudence with Dr. Aman Hengorani. Welcome, sir.
Thank you.
Before starting, I would just like to give you a brief introduction about Mr. Hengorani. Uh, he is advocate on record at the Supreme Court of India. He is appointed as amicus in various cases to assist Supreme Court. Uh, what separates Mr. Hingorani from others is he is genuinely devoted to devotes a substantial part of his professional time for pro bono work on behalf of the disadvantaged sections of the society. He was the counsel for the family of Nirbhaya, challenging the constitutional validity of the Juvenile Justice Care and Protection of Children Act 2000, granting immunity from prosecution to the juvenile found guilty in the infamous December 16 gang rape case. He has served on various government and non-government committees in such pro bono endeavor. As most of us know that he is a seasoned mediator. He has been engaged in teaching law and professional skill development since 1998. He is a frequent and a popular lecturer not only in India but abroad in various universities including Oxford and Warwick. He has developed ADR material for AIBE and FICCI also, amongst the other things. He has developed a very unique project, which is the Indo-British project on advocacy skill training with the British Consul in New Delhi. He is not only this, he is a acclaimed author. His best-selling book on Kashmir titled Unraveling the Kashmir Knot. It is a bestseller and it gives the perspective which most of us were not aware about Kashmir. He has got another 55 publication, both national and international, on various subjects, ranging from PIL to the Bhopal gas tragedy to the grant of intellectual property protection to genetically modified organism to the dynamics of global missile proliferation. I mean, we have got a very learned author today. And before proceeding, I'll just let you know what we are going to talk about in this webinar. This webinar will explore the Indian PIL as a legislative strategy to protect human rights with emphasis on the distinctiveness from other forms of public interest court action. This webinar will also examine the current trends in filing PIL matters as also the judicial handling of these matters. The webinar concludes with the evaluation of whether it is time to reclaim PIL for the benefit for those whom it was originally conceived. As you know, right now there is a gross misuse of PIL jurisdiction. Before I hand over the mic to Aman sir, just few preliminaries about this webinar itself. This webinar will last for around 40-45 minutes with the expert opinion from the sir, and thereafter we will be taking your queries. And this is live available on the YouTube. You can watch this webinar and our previous webinar at youtube.com/c/ebclearning.com. And in the end, I will be taking you tour of our website, ebclearning.com. As you know, I have told you in beginning also that EBC Learning is the e-learning initiative of Eastern Book Company, the leading publishers of the law books and the Supreme Court cases, SCC Journal and the SCC Online. So over to you, sir.
And thank you, Charul, and warm welcome to all the participants. Before we get into the issue of revisiting Indian PIL, let's examine what is PIL.
Correct.
Most of us are practicing lawyers, so we have an idea of what PIL is. But let us get into the jurisprudential part of it. As we all know, what is the traditional judicial role, that is to decide cases. So if one person has a dispute with another person, they go to a court of law which decides the conflict. So the traditional function is adjudication. We inherited this system from the British, the common law system. And within this adversarial system, the courts have adopted different approaches. You could have a natural law school or a positive law school. Natural law school very simply means that we all are born with human rights. Law only recognizes them. Law does not give them. Law only recognizes pre-existing inherent human rights and so law can't take it away. Positive law school basically, in simplistically put, says that law gives you rights and law can take it away. So our Supreme Court also has swung between positive law school and natural law school right from 1950 onward. We started on a positive note. A.K. Gopalan's case, if you remember, if you recall, A.K. Gopalan was the state of Madras, citation AIR 1950, Supreme Court 27. In that case, the view or the approach of the court was that all we need to see if the law is validly made, the proper quorum, parliament, etc. We're not seeing the fairness of the law. So, giving a common example, um, which is given in textbooks, suppose somebody steals bread and punishment is you hang him. The court will see if it's validly made, we won't interfere. We are not concerned with the fairness or the justness of the law. So that was the initial approach of the Supreme Court in 1950. It swung in different judgments to the natural law school. So you had Golaknath's case. Golaknath was the state of Punjab, EIR 1967, Supreme Court 1643, where the court took the view that fundamental rights guaranteed in Part 3 are inherent in every individual, and hence they cannot be abrogated, they cannot be taken away by the state. We again swung back to the positivist law school. The most famous example is ADM Jabalpur versus Shivkant Shukla, the habeas corpus case, AIR 1976, Supreme Court 1207, where again the view seemed to be that law gives you rights, law can take it away. So even your remedies to go to a court, your judicial remedies get suspended during emergency. We swung back to Maneka Gandhi's case, natural law school again. Maneka Gandhi was the Union of India, AIR 1978, Supreme Court 597, where the court said the procedure, Article 21 says no one should be deprived of their life and personal liberty except by procedure established by law. So that procedure established by law must be fair, just, and reasonable. So you've got procedural due process in our constitution. Another example of a natural law decision of the Supreme Court within the adversarial system is Sunil Batra versus Delhi administration, AIR 1978, Supreme Court 1625. We also had within the adversarial system public there many mechanisms to espouse or to protect public interest. So you had class action, for instance, Order 1, Rule 8 CPC, where any member of a class having a stake in the matter could move the court, having airing a grievance for the entire class. Now, all these were adversarial, and there are certain implications of that. Certain rules have been framed that which ensure that it's only the aggrieved person which comes to court, not a busybody. So you need to have locus standi. But more importantly, it also ensures objectivity. That is, there are checks and balances on the judge. The judge is bound by the pleadings, judge is bound by the issues, judge is bound by the evidence. The judge has to decide on what is on record. The judge cannot intervene in policy decisions. A judge cannot go around legislating. So basically, you have a particular judicial role to decide a conflict, putting checks and balances on a judge. And those checks and balances are what brings objectivity. So that regardless of which judge hears a case, if these are the rules which are applicable, there will be a standardized result. Of course, within the system, you have judicially active judges, you had some judges who are quite conservative, that's a different issue. But at least there was a standard. So this was right from 1950 to 1978, when in 1979 the Supreme Court was confronted with different kind of cases. The under trial prisoners case, Susara Khatun versus State of Bihar, AIR 1979, Supreme Court 1360, where it was found that people were languishing in jail for periods longer than had they been tried, convicted, and given maximum sentence. So, for example, if somebody's stolen a bike and the sentence is 6 months, this person is in jail for 20 years awaiting trial. a person is a victim of a crime, say rape, her presence is required to give evidence, but she is kept in jail. So that because there's no other place where they can house her, that she's put in jail so that she is available at the time of trial. Now, in these kind of cases, there's no dispute. You can't keep people in jail for periods longer than the maximum sentence they could have got, even if they were guilty. You can't keep people who are victims of a crime in jail. A similar case, Bhagwal blinding, 33 people blinded by police using needles and acid to teach them a lesson. Now, regardless of the offense or suspected offense, they were alleged criminals, you can't blind people. So there is an obvious violation of a fundamental right. There's no list, there's no dispute, there's no conflict. You can't do this. It is in these category of cases that PIL evolved as a remedial jurisprudence, non-adversarial jurisprudence, as a collaborative jurisprudence, because Article 32 of the Supreme Court basically says the right to move the Supreme Court by appropriate proceedings to protect fundamental rights is a fundamental right itself. So the Constitution puts a duty on the Supreme Court to protect fundamental rights. You could do that within the adversarial system, but this was a case where two lawyers filed a PIL, the first PIL in this country, saying that as citizens of the country and officers of the court, it has come to our notice through press reports that this is the prevailing state in Bhagalpur, in the state of Bihar. And it's the job of the court to protect fundamental rights. We are bringing it to your notice. It's your job now to protect the fundamental rights. So the court has to shoulder the task of investigating the correctness of this report. Is it actually the situation? The court has to monitor the situation. So it court needs to investigate, monitor, and then devise reliefs to protect human rights. It's not the job of the petitioner. Petitioner is bringing it to the notice of the court that this is the state of affairs. These rights are being violated. These people don't have access to court. They're not our clients. We don't have the wakalatnama. But we are moving you for you to discharge your constitutional obligation to protect the fundamental rights. So basically, PIL is a remedial jurisprudence by which the petitioner, the state, and the court collaborate to protect the fundamental rights of a section of people or even an individual, like the Gujarat case I'll just talk about. People who, because of some disability, do not have access to court. So it could be illiteracy, it could be poverty, it could be being possibly mentally ill, any kind of disability by which people can't approach the court. Another member of the public acting pro bono, without any ulterior motive, without having a stake in the matter, can approach the court and say, please protect their fundamental rights. The Constitution of India does not permit PIL, but the language of Article 32 is wide enough not to prohibit PIL. It simply says the right to move the Supreme Court to protect fundamental rights is guaranteed. It does not say who will move the Supreme Court. The right to move the Supreme Court to protect fundamental right of others through appropriate proceedings. It does not talk about the form. It need not be a writ petition. It could be a telex, it could be a letter, it could be so moto. Appropriateness is with reference to the purpose of proceeding, not the form of proceeding. So this is the way where we started having, where PIL started evolving, where the court expanded the scope of Article 32 to bring about this concept, and in the process also expanded the kind of reliefs that can be given. So if you talk about Article 32 again, which provides that you can have not only the five traditional writs, habeas corpus, quo warranto, prohibition, certiorari, mandamus. I hope you know what these all are. Habeas corpus is produce the body, certiorari is seeing the legality of the order for inferior tribunal. Prohibition is like injunction. Quo warranto is asking how you're holding a political office. Mandamus is direction to perform a statutory duty. So not only do they have the powers to do this five traditional writs, but any kind of order in the nature of these five writs, and hence an order, for instance, of filing, issuing, giving compensation. in addition to what a person may have under the civil law or the criminal law. So, for instance, Rudol Shah's case. Rudol Shah, AIR 1983, Supreme Court 1086, is a matter where this Rudol Shah was arrested in 1953 on charges of murdering his wife. He was put to trial. The Sessions Court found him, acquitted him, and said release on further orders. Those orders never came. So by the time the matter came to Supreme Court in PIL on the basis of a letter and press reports, the Supreme Court intervened. Rudol Shah had spent 14 years in jail after his acquittal. And that was the first case in Indian history where compensation was awarded under Article 32. So this is very broadly, simplistically put, the reason why we had PIL, the purpose of PIL, the jurisprudence of PIL, which eventually was expanded by the Supreme Court in 1980s.
Right, sir. So, if you look at what are the distinctive features of the Indian jurisprudence of the PIL, you will look at.
So if we compare just, let us just compare Indian PIL with other kind of public interest actions under the common law, say class action. So as far as Indian PIL is concerned, as I pointed out, it must lack a dispute, a list. It is non-adversarial. It is in nature is collaborative, it's investigative. In Bagru Blinding's case, which I just mentioned, the citation is AIR 1981 Supreme Court 928 and AIR 1982 Supreme Court 1008. The Supreme Court sent the registrar of the Supreme Court to investigate. So it is investigative. The judge can have a proactive role, can go beyond the pleadings, beyond the evidence to find a systematic reform. So the judicial function is different altogether. It ceases to be adjudication, it transcends to become something much more, a monitor, investigator, a forum. It can even impinge on policy issues if policy issues are violating fundamental rights. It can even legislate when there's no legislation. So you had Lakshmikant Pandey's case, adoption of Indian children by foreigners where there was no law. Supreme Court legislated. You had Vishaka's case where there was no law on work of sexual harassment of women in the workplace. Supreme Court legislated. So to the extent it is necessary to protect fundamental rights, the Supreme Court can forge any tool. They can do anything they want to do. They aren't bound by the checks and balances of the adversarial system. And so they can do whatever they want to do to protect fundamental rights. The Supreme Court makes procedural law flexible, doctrines like res judicata, latches are not applicable. Local standard gets relaxed so that anybody can move the court pro bono on behalf of those which who do not have access to court. It can be initiated by telex or telegram. You don't need a formal petition. There can be suo moto action by the court itself, cognizance taken by the court itself. And very importantly, unlike traditional cases where you need to first lead evidence, etc., make a prima facie case for grant of interim relief, in a PIL, the court gives the relief immediately, interim relief immediately, and then proceeds to do systemic reform. So in Sarah Khatun's case, interim orders are passed immediately so that about 40,000 prisoners were released within about 6 months. The case was eventually disposed of in 1994. So grant of immediate relief. And then, of course, there are other distinctions like a petitioner is not dominus litis. He's not driving the case. He's just bringing to the notice of the court. This is a kind of situation which is prevailing. So even if the petitioner seeks to withdraw, he cannot withdraw the case. Court will substitute him and the person will continue. So if we contrast this with the traditional public interest actions like class action, there has to be a dispute. It is adversarial in nature. The judge is bound by the pleadings, issues, evidence. It can't take a proactive role. The court can't get into policy issues. It will not legislate. It will insist on procedural law, give notice to all the people affected in that particular class. Only the aggrieved person can file the case. The burden is on the aggrieved person, the petitioner, to prove his case through legally admissible evidence. The identities will identify. There's identities, they're satisfied who are the affected people. In PIL, is a amorphous nature parties. Generally, everybody who is affected, they need not be before the court. And then again, in a traditional public interest action, like a class action, the court is going to give interim relief only after you establish prima facie case, balance of convenience, irreparable injury, and so on and so forth. So Indian PIL is a non-common law system. It's a remedial jurisprudence. It's unique in the world. So far so good, because here by relaxing the burden on the petitioner from proving the case and from going to the credentials of the petitioner, there's no danger because you're trying to protect the fundamental rights of a disadvantaged section of society. Similarly, there's no problem in relieving the judges from the common law restrictions, because here the purpose is different. The problem comes when PIL gets expanded, the expanded role of PIL, which happened with S.P. Gupta's case in 1982, that is the 1982 Supreme Court 149, the first judge's case, where Supreme Court expanded the scope of PIL, and that, in my view, is leading to all kind of issues which we see till date till 2020.
Right, sir. So we have got some law students also in this webinar, and for their advantage, I would just like to tell them the first PIL that was filed by Mrs. Pushpa Kapila Hingorani, who is Sir's mother and is proudly known as the mother of PIL. And that was the first PIL ever filed in India, and that was the real essence of the PIL that we used to see. But now PIL is, in my opinion, it is getting abused a lot. So if you can take us the journey, in the terms of the like they are these days issue continuous mandamus, like they start with a small problem and then they keep on expanding the scope of the PIL itself. So your views on that?
You see, just to complete what you said, yes, it was my mother who filed the first PIL, but it was my father who came up with this idea, and he's the one who drafted the petition, though my mother argued it. So, and that's what the Supreme Court, when they gave the full court reference in the honor of to pay homage to my father and mother, they
Right.
talk about his contribution in conceiving this whole idea. PIL is not just conceived, which is the common perception. PIL is conceived by lawyers who took this to the court, but PIL is definitely just developed, and development is in terms of expanding the scope of PIL. And let me explain by what I mean by that. As you rightly pointed out, PIL was meant to protect the poor, those people who did not have access to court. But what the Supreme Court did in S.P. Gupta's case is they expanded PIL to say that we will also entertain as PIL matters which relate to diffuse or collective rights, which cause public injury at large. So, rule of law issues, governance issues, environment pollution, and so on and so forth, which are issues which can cause public injury to an indeterminate number of people. Now, these kind of issues, they're important, they're very important. But these could have been litigated as class action, complete with the checks and balances on the judge. The checks and balances of the judge, which I point out in PIL cases, which stands relieved, is a judge can do whatever he or she wants to do to protect fundamental rights. And they're not bound by pleadings, evidence. They can do systemic reform. They can keep doing this convincing mandamus, whatever they want to do. Now, if you relieve the judges from those checks and balances in a PIL which can be litigated as a class action, then what you're doing is you're bringing in subjectiveness, because in a class action, there's still adjudication. In the traditional PIL, there's no adjudication. But in the kind of class action PILs, which I mentioned, rule of law, environment pollution, banning smoking public, CNG buses, there is some amount of adjudication, some kind of balancing of interests, which is done by the court. In Doon Valley case, whether it was with the environment, development, rights of the labor, so on and so forth, there is a dispute. So here's a situation where the court is trying to decide a dispute minus the checks of the common law system on the judge, as a result of which every judge will bring in his own thoughts, his own value system, his own beliefs. In other words, it will be a subjective exercise of discretion. It will take away from the objectivity. Because it is subjective exercise of discretion, it becomes an arbitrary exercise of discretion. And so we have seen in so many cases, one kind of cause which is taken as a class, which is a class action, but taken as a PIL, one bench will take one view on it. The roster changes, goes to another bench, they will have another view on it. The reason for this is that the system permits each judge to bring his own subjective views. Because in a PIL jurisdiction, the common law restrictions on the judge have been removed. So according to me, the Supreme Court has wrongly, maybe with the best of motives, to bring accountability, etc. But according to me, the Supreme Court has wrongly expanded the scope of PIL, the scope of judicial review, to bring within PIL matters that could have been litigated within the adversarial mode, complete with the checks and balances, both on the litigant and the court. And because of that reason, we are seeing the kind of issues which are coming out here that, in fact, if we talk about the development, right from after 80s were the decades, 1980s were the decades when people were litigating, filing PL cases, highlighting the grievances of the marginalized. But if you see later cases, 90s, 2000s, right up till date, the PIL movement has been hijacked by middle class interest. The kind of cases which we see right now, even if they involve violation of fundamental right, but could have been litigated within the adversarial mode, even those cases are more of the nature of class action. So environment pollution. MC Mehta's cases, I would say, are class actions because everybody is affected. We all have a stake in the matter. So they should have been litigated as a class action in the Supreme Court. The same judgments could have been passed under the Article 32, but with the check and balances on the litigant and the court. The fallout of all this is that today PIL has been hijacked by issues relating to the middle class. Nobody files cases relating to the poor. Nobody files cases relating to the disadvantaged. People are filing cases for different reasons, whether it's publicity, whether they feel that this is a cause. And incidentally, even the Supreme Court guidelines do not draw these distinctions. We had a decision of the Supreme Court in 2010, which was, I can give the citation of that particular judgment. It is 2010, Volume 3, SCC, page 402, State of Uttaranchal versus Balwant Singh Chauhal, where the Supreme Court talks about the different phases. First, for representative phase, where it was for the poor, etc. Then governance or rule of law or accountability, and then environment, etc. But the guidelines laid down is, Supreme Court actually says the court has to be prima facie satisfied about the credentials of the petitioners. Court has to be prima facie satisfied about the genuineness of the contents of the petition. Why? Why should this be a requirement for cases when a person is bringing a violation of the fundamental right of the poor to the court? This may be a condition for PILs where you talk about citizen standing, class action kind of PILs, because you want to stop misuse. But by putting these kind of conditions, even for PILs which are meant for the marginalized, for the disadvantaged, you're actually taking away the sense of PIL. You're putting the burden on the petitioner. How can the petitioner be basing the case on press report? Why is the press report not good enough if a press report is good enough for the court to take some more action? Why is the press report not good enough if a telex is good enough or a telegram is good enough? Why should the credentials of the petitioner be seen? Why should there be an onus of proving the case on the petitioner? Why should the petitioner have to show that prima facie the petition is correct? Because the job of petitioner is only to bring to the notice of the court that this is a violation of fundamental rights of this disadvantaged section of society. Is the job of the court to investigate. So, but by bringing these kind of guidelines, which apply to all kind of PILs, including represented PILs, you have blunted the instrument of PIL. The casualty is the poor, the marginalized.
True, sir. That is what we are facing. Like before filing any PIL, I have to prove my credential. And idea was always to bring the cause to the court and then court to investigate through the commissions and whatever. So before I start, I just want your thought because it is very frequently written about that the way the Supreme Court conducted itself during the time of emergency and the decisions we have, the ADM, Jabalpur and all. So to redeem itself, it started the PIL jurisdiction and social action litigation. So your views on that?
Well, I don't know, say, whether it's institutional politics that because there was a political vacuum after emergency and the Supreme Court got into the political vacuum and played politics of poverty. That's the view by many commentators. For me, the kind of cases Supreme Court was confronted with, under trial prisoners case, Bhagapur Blanding's case, they were such hard cases that any court would have to take action. So, and in the process, if the court enhances its own legitimacy, its own credibility, there's nothing wrong with that because they are meant that they have a constitutional obligation to be the protector of fundamental rights. But so far, so good. But if they go one step further and try to enlarge the jurisdiction to bring into cases which talk about diffuse collective rights, and since that would virtually bringing in the whole issue of governing the country within the scope of unelected judges in the Supreme Court, then that criticism may have some merit that can the court widen the scope of judicial review to such an extent that whatever falls legitimately in the scope of the jurisdiction of the executive legislature, the court takes it over. So if the question is that this was only a tool to win back legitimacy, I may not completely agree because the court actually had no option when confronted with these hard cases, whether it subsequently became a tool by which the court wanted to usurp political power. There have been plenty of people who have written about it, and there may be some merit given the certain kind of cases the Supreme Court has taken up, and also the subjectiveness by which the Supreme Court has taken up those cases. But those subjectiveness, people have attributed motives or things like that. I don't attribute motives. I say the system itself permits them to be subjective. And that is what we need to check. We need to revisit the law laid down on PIL. We need to revisit the guidelines. We need to revisit what, like you're saying, why should we need to prove our credentials or the content of the petition in certain kind of cases, and so on and so forth. So that in that sense, we need to reclaim PIL for the people for whom it was conceived, the poor and the disadvantaged.
Right, sir. So, yeah, what is your advice? Like nowadays, the PILs that are coming, we get to read it online also. They just write whatever they feel like without any research or without even applying the legal principle. So, how would you direct people to file a good PIL? What should it contain?
You see, because of the undue expansion of PIL that was leading to misuse, which led to the Supreme Court in the decision I just told you, Balwant Singh Shawfal, highlighting the misuse and suggesting that every high court should frame their own rules. Pursuant to that, rules have been framed by virtually all the high courts, which laid down the guidelines about how to file a PIL. And one of the guidelines, or some of the guidelines, is that the person has to talk about, tell their credentials. They have to show why they say that this particular report is genuine. So some amount of research is required. According to me, it's an unfair burden on the petitioner in certain kind of PILs meant for the poor. But be that as it may, that is the requirement today. So whoever wants to file a PIL today should first look up the guidelines or the rules framed by the respective high court, and they would have to file an affidavit in support of the petition, which is again inconsistent. If courts can do so motor action, or I can send a telex or letter directly to the court, it is a bit silly to require a petitioner to file an affidavit. So, so they don't serve much purpose, but they're supposed to file those affidavits as per those rules. So whoever today wants to file a PIL cannot or would not take, or if they want the case to be taken seriously and for the court to apply its mind, they would need to give all the particulars specified in the rules. And the high court, each high court, they have their own set of rules. So they would need to go to each high court, depending on whichever high court want to file, because high courts have concurrent writ jurisdiction under Article 2 to 6. That will also, one has to keep in mind is that while the full bench of the Supreme Court in Ramesh Thapar's case, 1955, had said that it's a constitutional duty of the Supreme Court to entertain writ petitions. It can't be thrown out because of an alternative remedy. You have the Kochuni's case in 1959, 9 judges of the Supreme Court saying that even the existence of alternative remedy does not mean the Supreme Court can throw out the writ petition, even if it involves disputed questions of facts. But in 1980s, there were two judge bench decisions of the Supreme Court, which completely overlooking this larger constitutional bench decisions, have laid down that when the High Court can give the relief, go first to the High Court and then come to the Supreme Court. So whoever is filing a PIL today, because PIL is confined to writ jurisdiction, Article 32 and 226, they will also have to see whether they want to come directly to Supreme Court, whether the case merits that, or whether they would have to go to the High Court. So the points which a person, PIL litigant, must keep in mind is, which is the right forum? Is it the High Court or the Supreme Court? Because if they come straight to Supreme Court can simply say, go to High Court. High Court can give that relief. According to me, again, a wrong practice, which is inconsistent with larger constitutional decisions of the Supreme Court. But that's a different issue. The Supreme Court can tell the litigant, go back to the High Court. So let them see whether they want to first approach the High Court or the Supreme Court. Jurisdiction of the High Court is wider. It's not only fundamental rights, it's for any purpose or any legal right. And not only against state as strictly defined in Article 12, any public authority. So it's a wider jurisdiction. So the litigant should see whether to file in High Court or Supreme Court. If in the High Court, what are the rules applicable? What are the requirements there? And then tailor make the particular petition.
Right, sir. So there are few queries which are coming. I think now we can open the forum to the.
Sure.
I'll just in the chat section. So there are some queries. You can also read it.
Okay.
If you click on the chat icon, you can find the queries as well. I can read it for you as well.
So which would you want me to answer? Because I've got them. I've got a question that middle class is most disadvantaged today. No case where middle class poor and which are taken care by government was strong in middle class is using PIL. Well, there's nothing wrong if middle class also files PIL. The issue is not who's filing it. In fact, anybody can file PIL. Issue is the purpose of filing PIL. PIL is a tool basically essentially meant for those category of cases where there's no conflict, whether it's for poor, middle class, or the rich, but there should be no dispute. The person filing the case should not have a personal stake in the matter. And he or she should be highlighting the issue for people who otherwise cannot have access to court. In S.P. Gupta's case, only the Supreme Court has laid down that if there's a section of people who have access to court, but they choose not to go to court, you can't file a PIL for them. Now, if you do have access to court and you are aggrieved by a particular issue which affects the middle class, you must go to the court as a class action. So nobody's saying you can't go to court. We are just talking about fine-tuning PIL to confining it to people who don't have access to court. Those who have access to court and have an interest, go to court, nobody's stopping you. So the question that I should not be construed by saying that the middle class should not use PIL. I'm more concerned about the purpose why they're using PIL. Now, the question next question is, I would like, what's your view on the petition for change of name of India to Bharat? Now, you see, the only standard, the traditional judicial role is adjudication. The only area where the court can depart from this traditional role is in Article 32, because apart from the jurisdictional advisory and Article 143, etc., that's different. But within writ jurisdiction, the only limited area from where the court can depart from the adversarial system is under Article 32 to protect fundamental right. Every 32 petition must relate to the violation of a fundamental right, actual or suspected or apprehended violation of a fundamental right. Now, when you're talking about the change of name from India to Bharat, whose fundamental right is violated? So from where did the court get the jurisdiction to get into this issue? Even within traditional Article 32 petitions, if you want a constitutional amendment, the forum is Parliament. Government has to introduce it. So I'm not on the merits of the petition. I'm just saying this is the wrong forum. This is not a PIL matter. It is a policy matter which should be considered at the level of the government. And if they feel there should be a constitutional amendment, nothing prevents them from introducing a constitutional amendment under Article 368. So, according to me, it's, of course, let's see what the court says about it. It's sub judice, so I don't want to really get into that. But in context of what we've been discussing, I would say it's more of a matter for the other organs of the state to see rather than the Supreme Court.
Just to add, like this PIL was somebody has filed 2 years back also for changing name of India to Bharat, and it was dismissed.
Again, I think taking the same view that that's more of the job of it's not maintainable. I think that was the view taken by the court, because for every PIL you must plead a violation of fundamental right.
It is becoming more of the publicity stunt that most people are playing without getting adequate research about the topic and without realizing whether there is a violation of a fundamental right or not.
So that is again where the guidelines need to be tweaked. Right. The guidelines there should be very clear-cut guidelines laid down by the Supreme Court. According to me, the guidelines are confusing.
Right.
Now the question is, what is the solution for frivolous PILs that are being filed in court? Well, the courts have evolved many solutions, imposing costs, heavy costs, where they feel they're frivolous, with the caveat which I would like to give: what if it's actually not frivolous, but in the subjective view of a judge is frivolous? That's why we need to take steps to get rid of that subjectivity that has been introduced by widening the scope of PIL so much. Now, there are other kind of ways courts have evolved. Many times the court says, with imposing cost, that a copy of this order will be filed, will be placed on record of any other PIL filed by this particular litigant, by the registry will place on record of any future PIL to be filed by this litigant. Many times, certain litigants are barred from filing PILs on certain issues. So, the courts have been passing these orders, which, according to me, are all unnecessary, because each of these kind of orders can also have a potential of being subjective and hence arbitrary. It is these kind of distortions will go away if we reclaim PIL to the original PIL or the traditional PIL meant only for the disadvantaged section of society. These kind of issues will not arise. They won't be frivolous PILs in the first place. Now, whether land matter in which the livelihood of farmers is given to Gram Sabha, whether after dismissal of SLP, can a farmers file a PIL? Obviously, no, because there are already a finding. But again, you see, one has to keep in mind, and that aspect has been explained in Khatri's case, Babu Branding's case, the scope of a PIL. The scope of a PIL is not to decide the civil or constitutional or criminal rights or liabilities of an individual. It is to see whether there has been a violation of a fundamental right. So if a case has been lost, if a case has been dismissed on merits, but there may be a facet of the case which results in violation of fundamental right, then to the extent there's a violation of fundamental right, a case will be maintainable. Not on merits of the case. We're not on the merits of a final decision of a High Court or a Supreme Court. We are on where there's been a violation of fundamental right, and that's the limited scope of a writ court in the Supreme Court. So if a person wants to file a petition, they would need to show how, despite the dismissal of certain litigation on the civil side, there's still a violation of a fundamental right. And if that can be maintained, then you can try your luck.
Sir, your views on the suo moto petition, which is cognizance which is taken by the court, and then they run it for a long time.
No, I'm very happy with the suo moto, where the courts are sensitive. We have had excellent judgments by the Supreme Court, which is the reason it has generally enjoyed the credibility and legitimacy, because it is perceived to be the humane court. It is not only, you have not abstracted socio-economic context, there's only a bundle of rights. It's not only case numbers. Courts have given very good decisions. but they have given those good decisions in context of people whose rights have been brutally violated. And nobody, there's nothing to decide there except that a recognition that these human rights have been violated and we must give them relief. So in those kind of cases, if the court takes suo motu action, I would welcome it. I would say it must be encouraged. And our courts have done an excellent job in the past. I'm not too sure about suo motu action by the court in cases where the courts need to adjudicate. And which takes me to the points I made earlier, a distinction between cases where you're fighting a case for those who don't have access to court representative standing, and a court is entertaining PIL in regards to a case where they need adjudication for a citizen's right being violated, a diffuse right being violated, citizen standing. So for representative cases, court must exercise suo motu jurisdiction, and they should be far more cautious if they want to do it for cases which involve some amount of adjudication, which relates to diffuse or collective rights.
Right.
Because there's another aspect of it. Courts are not experts. If you're balancing rights, say environment pollution, balancing rights between citizens, pollution, development, defense production, policy decisions, courts don't have the expertise. So it's not for the court to balance the interest. Court is only going to see whether the state has balanced those interests correctly or not. So those kind of cases, the court should be very cautious in treading.
Right. So there is somebody who's asking whether a land matter in which the livelihood of farmer is given to the Gram Sabha, whether after dismissal of SLP
Okay,
can the farmers file PIL?
I've answered that the scope of PIL is to see violation of a fundamental right if in a litigation, whether of the Gram Sabha, there's been some finality, you can't reopen that through PIL. But independent of that, if you can show there's been a violation of fundamental right, to that limited extent, you can file what you want to file. But you have to establish violation of fundamental right.
Right.
And that would also keep in mind Naresh Mirajkar's case, where the Supreme Court had laid down that when a court decides a case, they're not violating fundamental rights, they're disputing a dispute on merits. Though, of course, you have Andule's case, then you have Hura's case, where the court now has been taking a stand, and a right stand, that even a judicial decision can violate fundamental rights. You can, of course, see, but that's again a very, very narrow kind of cases which needs to be established on record that a particular decision has violated fundamental rights. ADM Jabalpur, for instance, is a good example of how about a judicial decision violated fundamental rights.
So then we have got some students, they want to file PIL via a letter to the CJI. They want to know the mechanism of following it up, whether it was taken by the court or not till it reached.
You see, most of the high courts now, the courts, every court has, as I pointed out, has their own rules. Most of the courts now also have PIL cells, where letters, when they are sent to the court, they are screened and then placed before the court. And then it's left for the court to take a call whether to treat it as convert it into a PIL or not. So if you have written something to the court, please, just read the High Court rules. Even if it's a letter petition, try to satisfy those rules, which include who are you, why are you filing it, who is it meant, on what purpose, what's the purpose of filing that particular case, what is the basis on which you filed the particular case, what research have you done. Please specify all that, and then request the court to treat it as to take cognizance of that particular letter as a PIL, and it will of course become a suo motu action. The other way of approaching the court is by simply, of course, filing a proper writ petition in public interest under Article 226, and of complying with all the High Court rules on filing of that particular writ petition as a PIL.
Right, sir. I think this is all we have. If you have any other queries.
Very well.
Right, sir. Thank you so much, sir, for your time. It was a learning experience for all of us here. And thank you all the participants for your time as well. Stay safe. Thank you, sir. Bye-bye.